Good morning. My name is Cheryl Eiffel. I'm a professor of law at the University of Maryland Law School, and I'm overjoyed to welcome you to this panel on race and the law in the wake of the 2008 election. We have a lot of ground to cover today, and maybe somebody has a computer and they're on SCOTUS blog in case Supreme Court cases are coming down even as we speak, and if so, we could change everything up. But otherwise, I'll try to set out what I think we're going to talk about today and how we're going to talk about it. So much, of course, had begun to change before the 2008 election, and so I don't mean for this panel to set up what is a somewhat artificial marker of a kind of moment of change that is implied by the title Race and the Law in the Wake of the 2008 election. 2008 may just have been a pivotal moment in a gathering transition on many fronts. It's hard to imagine, for example, 2008 happening without the seminal week in 2006 when the Katrina floods engulfed New Orleans. But certainly something has shifted. In fact, a number of things have shifted, and they do and will affect how race and racism is understood, framed, and addressed in the law, whether we're talking about litigation, legislation, regulation, or legal policy. The obvious defining event is the election of Barack Obama as the first black president of the United States. Within that, there are other, of course, key moments: his win of the Iowa primary, the racially contentious South Carolina Democratic primary, the campaign itself and its use of opportunities for small and engaged internet donations and relationship with the campaign, the importance of early voting in the campaign, and the importance of the youth vote. And of course, the willingness of a significant number of white voters in many states, and 43% nationwide, to vote for a black presidential candidate, which, while very important and quite hopeful, may obscure continuing racially polarized voting and racial barriers to voting at the state and local level in a number of jurisdictions. Yet another defining event is the crushing financial crisis with its devastating consequences for many middle and working class homeowners. It was Oliver and Shapiro in Black Wealth, White Wealth who demonstrated empirically that the wealth of most African Americans in the middle class, such as it exists, is almost exclusively based on the asset of the residential home. The current foreclosure crisis may therefore represent the largest loss of black wealth and land in the history of this country. Lawsuits like those filed by my city, Baltimore, against Wells Fargo Bank for targeting subprime mortgages at African American communities may open a further window into predatory and racially disparate lending practices and may further deepen a civil rights engagement with economic justice issues. The past 2 years have also found a reversal in harsh and rigid mandatory sentencing laws and disproportionate sentences for crimes associated with the sale and distribution of crack cocaine, both of which have been key factors in the massive over-incarceration of young black and Latino men and women for drug crimes. And so we may be at a key moment to look more closely at matters related to criminal justice. After 7 years of No Child Left Behind and with a new administration in Washington, we're poised to have a renewed conversation about education disparities, including the schoolhouse to jailhouse pipeline. And we're seeing the beginnings of what is likely to be a full-scale dynamic engagement with immigration reform that will no doubt be shaped and affected by the political changes here in Washington over this past year. It seems almost too obvious to mention that the Supreme Court stands poised, even as we speak, to decide two cases that may change the landscape of how we deal with two critical civil rights issues, voting and employment. The North Austin Municipal Utility District case presents a frontal challenge to the constitutionality of key provisions of Section 5 of the Voting Rights Act, and we're privileged to have one of the attorneys who argued that case before the Supreme Court with us. And the Ricci versus De Stefano case addresses the ongoing power of local jurisdictions to voluntarily engage in actions designed to promote diversity in public sector employment. Finally, we're poised also to confirm the first Latina Supreme Court justice. This nomination has already unleashed a contentious conversation about so-called identity politics, which will affect the atmosphere in which we litigate, legislate, and regulate issues around race. To discuss these and many other issues, we have a dynamic panel of civil rights lawyers and thinkers and one legislator. Our job is to lay on the table some of the framework for whether and how the 2008 election or events over the past year or just the moment that we're in today has or has not changed legal issues related to race. Our format is one that we hope will emphasize dialogue and engagement over presentations. I've asked each speaker to give us no more than 10 minutes to lay out one or two of the areas I've identified. So that should take us about 40 minutes. We'll then turn to a discussion amongst the panelists in which I'll pose some questions based in part on some of their presentations, but also with some surprises. And the panelists will have an opportunity to ask questions of one another. And finally, we'll spend the last 15 or 20 minutes taking questions from you. And so I hope that you will listen quite closely, be fully engaged, and be prepared to ask questions as we close. Let me very briefly introduce the panelists. You have their biographies in your materials. I'm going to introduce them in the order in which I've asked them to speak today. The first panelist is Representative Terrence Carroll. He is the Speaker of the House of the Colorado General Assembly. He's the first African American in that top leadership role, and he actually just shared with me he's the only African American in the Colorado General Assembly. He served for 4 years as chairman of the House Judiciary Committee. He's also an attorney with Greenberg Traurig, and he is an ordained minister, which is why I asked him to go first in the hopes that we'd be covered by some divine favor. I then would like to hear from, and hope we'll hear from, Michael Rossman. Michael Rossman is general counsel at the Center for Individual Rights, a public interest law firm here in Washington, D.C., where he has litigated a number of high-profile constitutional law cases, including United States versus Morrison, in which he was counsel and argued the case in which the Supreme Court struck down key provisions of the Violence Against Women Act, and Grutter versus Bollinger and Gratz versus Bollinger, in which the Supreme Court upheld key aspects of the University of Michigan's admissions practices. Then we'll hear from Vanita Gupta. Vanita Gupta is staff attorney of the Racial Justice Program at the American Civil Liberties Union. She litigates civil rights cases related to criminal justice, education reform, and immigrants' rights. She's also a former assistant counsel with the NAACP Legal Defense Fund, where many of you may know of her great work working for the successful overturning of drug convictions of 38 African Americans in the town of Tulia, Texas, who were racially targeted. And then finally, we'll hear from Debo Agdebele. Did I pronounce it correctly?
Yes.
Agdebele, who is the Director of Litigation at the NAACP Legal Defense Fund, where he oversees the legal program and supervises the legal staff in the area of criminal law, economic justice, education, and political participation. He himself has worked on a number of important and high-profile cases, particularly those focused in the voting area, including North Austin Municipal Utility District versus, Holder now, which he argued before the Supreme Court, and I'm sure he'll be anxious to talk with us about that. He was a litigation associate prior to joining the Legal Defense Fund at the law firm of Paul Weiss, Rifkin, Wharton, and Garrison. Please join me, first of all, in a round of applause to encourage and welcome our panelists. Representative Carroll, would you begin?
Thank you. I'm not sure if I'm supposed to give an invocation or just jump right into this since you asked for some divine assistance in this process. I am the only African American in the Colorado General Assembly, which makes our Black Caucus meetings quite easy to get through. They used to be much more difficult when there were 4 of us, but now that there's only 1, I can get my way all the time, which is good for me. I'd also like to acknowledge that today is Juneteenth, and for those of you who are from back west or Texas, you understand the significance of Juneteenth, so it's actually quite interesting that we're doing a panel on race and the law on
Tell the people what
Juneteenth. Does this count against my 10 minutes if I do this?
Let us carve out 30 seconds for a Juneteenth explanation. Now.
Sorry. Well, Juneteenth is the day that African Americans in Texas generally found out that Abraham Lincoln had emancipated the slaves back in 1863. They didn't find out for some 18 months later. And so we celebrate Juneteenth throughout the West and in Texas in the African American community. And in fact, in Boulder, Colorado, where there's only 3 African Americans, they actually have a huge Juneteenth celebration.
And everybody gets the big piece of chicken.
I have to stop. I'm going to be serious now. So I'm going to take a few minutes to speak about race and law from the perspective of someone who's a policymaker and some of the issues that we actually have to face in regards to this as policymakers. In Colorado, you wouldn't think that we would spend a lot of time thinking about race as it relates to the policies that we pursue, the legislation that we enact. But the truth of the matter is, every single thing that we do to a certain degree, especially some pretty particular areas, actually have a racial component to them, whether we admit to it or not. And those issues tend to be immigration. We have most state legislatures, and even at the federal level, we're having significant discussions about immigration. Education reform has a significant racial component to it and how we implement that. And we just saw that recently in the Parents Involved case and Greta before that. Voting rights laws and voter ID laws. If you listen to the discussion across the various states, it comes with a great deal of racial fear and animus that's intertwined within that conversation, especially if you listen to the Minutemen. We heard criminal justice referenced earlier, and that's an area that I've been completely involved in during my 7 years in the General Assembly. Because when you look at even a state like Colorado, where we have 4.5 million folks, and 4% of the population is African American and declining actually each year as a percentage of the population. 25%, much like the national average of our populace within our prison system, are actually African Americans. And when you go to Latinos, that's almost 40% of our prison population are Latinos, although they're only 25 to 30% of our population in Colorado. And the one area, which is the sleeper area that we always have to address if we're going to talk about race and law, race and public policy, are disparities in health care, which I think is very much so the most sleeper issue when it comes to discussions about race and public policy, because we don't spend enough time looking at the fact that in African American and Latino communities there is a significant shortage of physicians. Latinos and African Americans have a higher likelihood of being killed by certain diseases, and most of those are preventable diseases or chronic diseases that can be managed with the right type of care. And so having raised those issues, the question in my mind, in terms of people who are public policy makers, how do we respond to this and what do we take away from these issues? I want to talk about education first, because that's one of the areas that I think has the most important impact on race and law and race and public policy. And I always like to start by quoting Thomas Jefferson. And Thomas Jefferson, just to paraphrase, once said that education is that one thing that allows the person born of low birth to have the same opportunity as the person born of noble birth. And when you look at a city like Washington, D.C., that's a true statement. I actually grew up on the other side of the Anacostia in Southeast and Anacostia, and went to H.D. Woodson High School, for those of you who are from Washington, D.C. And if it wasn't for education and the opportunities that I've had available through education, there would be no way that I'd be in Colorado. I'd still be over in Southeast somewhere, hanging out on Malcolm X and MLK at that corner where I used to get my hair cut. But because of educational opportunities and the aggressive nature that some people took in terms of pushing me towards those educational opportunities, you wouldn't be listening to me at this point. But state legislatures, and even at the federal level, with the No Child Left Behind, many of the discussions when it comes to education have a disproportionate impact on black and brown people. For instance, charter schools. Charter schools actually serve more black and brown kids than they do Anglo kids in many school districts around this country. When you look at the composition of many of our school districts, less than 3 in 5 students are actually white now. And when you go to our most urban school districts, it's gotten to the point where it may be 1 or 2 within 5 are actually white students. And that has an impact on the quality of education that our children receive, not because white kids are smarter than black or brown kids. It's because there have been several studies that show that the lack of diversity within our school districts actually have a negative impact on both white students and students of color within their learning environments, because they're not forced to have that type of interaction. voting rights laws, which is the next issue that states have to deal with. In Colorado, every year we have to face an assault on voting ID laws that make it much more difficult for people to vote. And many of those conversations are conditioned upon the idea that brown people are crossing the border from Mexico to come into Colorado to vote. It's actually pretty absurd when you think about it that someone's actually going to leave Guadalajara to make that treacherous trip through Texas and then into Colorado and make their way somehow into the metro area and Denver and decide to vote for a black or brown person just to piss off white people. I mean, but that's kind of the discussion that you hear from folks who are part of the Minutemen movement. And I'm not sure if you're not from out west, you probably haven't had too much interaction with them. To be thankful that you haven't. So those are the issues that I hope that in the course of discussion and in the course of the questions that you raise to us that we're able to have a deeper discussion on, because I think they're important. And one last thing in conclusion, and I won't do the Baptist preacher thing because I'm a Baptist preacher, where we close 3 times before we actually get to it. I'm just going to close once and not even do a hoop. I'm just going to close. As a legislator of color, and this is why I sympathize with President Obama to a certain degree, there's a great deal of pressure on us from our own communities at times to push aggressively policies and agenda items that may overtly and directly impact people of color. But when you look at the positions that we have and where we are, we weren't elected by a majority of people of color. My House district in Denver is actually a majority white district. I don't represent very many African Americans in my House district. Maybe 10% of my House district is African American, and maybe 20% is Latino, and the remainder is Anglo with a few Asians spread in there here and there in the House district. And oftentimes the agenda that we have to push if we want to significantly impact our communities is an agenda that's not necessarily based on overt appeals to race, but appeals to economic disparities. And when you look at many of our urban areas, and even in some of our rural areas, and you look at the folks who are at the low end of the economic scale, they tend to be people of color. And we've taken the tact, and I hate to, quote William Julius Wilson, but I will. We've had to adjust our public policy positions to address that and to rely more on issues of class and economic disparity in order to work around some of the court's decisions on affirmative action and to work around the very real fear that many people who aren't people of color have when people of color assume positions of great authority, that somehow we're going to use that as a bludgeon and to hold their group down, which is what you're starting to see in the research from the Southern Poverty Law Center and the hate groups in their rise in this country right now. So I look forward to discussing this issue more with you all in the networking section.
Michael Rossman.
Thank you. First, I'd like to thank the American Constitution Society for inviting me to speak at this panel. It's, I think, a very exciting weekend that you have planned and that has already taken place to some extent. I'm going to speak as a litigator, which is what I am, and race and law in the wake of the 2008 election raises the issue of civil rights principles, civil rights policies. There are 2 possible ways, I think, that the 2008 election might change those principles and or policies in some substantial way so as to create maybe a new paradigm for civil rights. First, of course, as has already been mentioned, in 2008, an African American was elected president of the United States. Some people might think that that portends some changes in basic legal principles involving civil rights, perhaps less vigilance on the margin of some civil rights principles, perhaps some changes in the legal principles governing race-conscious decision-making that aid underrepresented minorities by private and public entities. Some might think that those changes would be warranted by the election of an African-American president. Second, some people might think that a more liberal Congress combined with a more liberal executive will yield more aggressive efforts at eradicating discrimination, however one defines discrimination, to yield perhaps again a new paradigm. Now, the first thing to note, of course, is that these 2 possible changes in attitude may be conflicting with one another. For example, those who have ascended to control the executive and legislative branches could believe that eradicating discrimination, as they understand it, requires a certain amount of race-conscious decision-making by public and private entities. That the two possible paradigm changes that the 2008 election might suggest to the average observer actually could conflict with one another supports the brief and perhaps overly simplistic hypothesis that I'm now presenting for your consideration. My hypothesis is that in well-developed areas of the law, and civil rights law, I should say, is one of them, the law tends to move somewhat slowly, at least insofar as the major tenets and principles are concerned. Change usually takes place on the margin. Basic fundamental principles will remain intact and not really change much at all. We'll still have race-conscious decision-making, but it will be fairly limited. The definition of discrimination, I don't think, is going to change dramatically. I'm going to just cite a few brief examples in the areas of employment law and voting law. And one of the first things the new government did in January was pass the Lilly Ledbetter Fair Pay Act. It is, I think, a change on the margin. Obviously not directly related to race, but I think it underscores the point that I'm trying to make. The Fair Pay Act changes the time that certain complaints of discrimination can be filed with the EEOC, but it is limited to, quote, discriminatory compensation decisions, unquote, a phrase, remarkably enough, that Congress did not bother to define. 6 months after passage, there seems to be some disagreement as to how to interpret that phrase, but the majority of courts have been interpreting it fairly narrowly so as to exclude, for example, failures to promote. Conceitedly, of course, it's still early. And in any event, I think even if it were more broadly defined, the vast majority of people who are discriminated against in that situation are going to try, if they can, to sue as expeditiously as they possibly can. In cases involving race or national origin, specifically, Section 1981 is always available to extend the limitations period somewhat longer than Title VII permits. So the Ledbetter law does not, I think, signal a substantial change in paradigm. The Ricci case was discussed very briefly earlier. I think there are two things to notice about that case. First, although it's a very hard case in some respects, or at least suggests some hard issues about the relationship between disparate treatment and disparate impact, I think one thing to note is that there seems to be some amount of sympathy for the plaintiffs in that case. When liberal columnists for the Washington Post suggest that plaintiffs may have gotten a short shrift from the Second Circuit, I suspect that support for hardcore racial preferences might be more difficult to come by. Second, although the case has certainly received a lot of publicity, especially in the wake of Judge Sotomayor's nomination, I think that the outcome of that case is probably not going to be making substantial changes. The basic principle that employers cannot use improper selection devices that have disparate impact will certainly remain. The best, my view, the best that the plaintiffs in that case can hope for is a ruling that mere disparate impact without any indication that the selection device is improper would be insufficient for an employer to cancel the results of an already scored exam. Merely stating the principle is to suggest that it is narrow. And if it is decided that way, and I don't know that it will be, the intelligent employer will adjust and make sure that it has additional evidence of the impropriety of the selection device before canceling the results of an already scored selection device. Would Congress and the President act to change the result in the Ricci case if it comes down that way? And if that's the result, I tend to think not. Of course, one can never predict those sorts of things. Anyway, one could argue that even if legal principles don't change, discretionary prosecutorial decisions might be different. Positions of the Obama administration certainly will be different than the Bush administration. And one example of that in the voting rights area is the decision to dismiss the case against the new Black Panthers Party. On the other hand, there are early indications that the positions are not going to be hugely different. In the Ricci case, let's not forget, the United States, as amici, supported vacating the judgment of the Second Circuit, a point that may have been overlooked sometimes in the more recent discussions of the case. DOJ's overall position, to be sure, was closer to the city of New Haven's than it was to the white firefighter plaintiffs, but it was nonetheless a middle ground. In a case in which I've been involved for a number of years, called the United States versus New York City Board of Education, which is before the Second Circuit, it involved the hiring of custodian engineers by the New York City School for 4 New York City school buildings and a settlement agreement that granted benefits to minority and women custodian engineers. The Obama administration's position right now is pretty much the same as the Bush administration's position. And I have to tell you, that position is not very favorable to the women and minority beneficiaries of the settlement agreement. So let me just make a few brief comments about the voting area. As I've said, some prosecutorial decisions will be different. The new Black Panther Party decision is an example of that. But again, I think it's an interesting case, but I don't think it's going to pretend any kind of major paradigm shift. And finally, the voting area and the civil rights area in general is an area in which the courts are going to have some significant role in any attempt to shift a paradigm. The Northwest Austin Municipal Utility District case that Eva knows a lot more than me about, I don't know how it's going to come out, and I don't know how important it would be if it came out that Section 5 was declared unconstitutional. The proportion of objections that DOJ is making these days is, I think, something like 0.3%. But important or unimportant, the point I wish to stress is that a holding that Section 5 is unconstitutional is not going to be subject to a very easy legislative fix. A politically astute administration, and I think at this stage most people feel that the Obama administration fits that category, is going to be mindful of the fact that any attempts at substantial change may be subjected to checks by what is still, I think, a reasonably conservative Supreme Court. So, concluding, my observation is that paradigm shifting is difficult, especially in a relatively mature area of law like civil rights. My prediction is that the 2008 election will pretend changes, but more modest changes on the margin. And with that, I will close and await the exciting and interesting discussions to come.
Thank you. Vanita.
Great, thank you. In many ways, the 2000 election was historic and groundbreaking and frankly astounding. I still have to pinch myself when I hear that Barack Obama is president. But it's interesting. When I was traveling around the country for various cases that I was working on during the election, I heard from a number of well-intentioned non-African Americans that they were afraid that if Barack Obama got the nomination and lost, there would be race riots. And then later hearing from those folks after the election that we were suddenly clearly living in a post-racial society. And it was this very kind of bizarre shift that suddenly happened, I think, in the minds of a lot of people. It still strikes me as very odd. And I think, assessing the state of racial justice or race in the law in America goes far beyond determining whether a black man in this country can become president. It requires really an investigation into the state of inequality and whether there have been any changes in opportunities for minority and marginalized communities. And so from my vantage point as a civil rights advocate so far, we aren't in a post-racial anything, whatever post-racial means. And there's no question that Barack Obama's election is a watershed moment in U.S. history, and there's no question that I think that his election affects the ways in which a lot of Americans actually now think about or have adjusted their racial attitudes. There was a recent New York Times CBS poll which frankly shocked me. It found that 2/3 of Americans now thought that race relations were good, and that perception had doubled among African Americans since July. So for people of color, Barack Obama's election really is a symbol of all that's possible. It is inspiring. It gives us hope. But his election and more broadly the Democratic control of Congress after this recent election hasn't changed some really kind of fundamental facts about inequality in this country. the first is very near and dear to my heart, and that relates to the criminal justice system, which is really at a kind of real crisis point right now. Just to throw out just a couple of statistics, probably a lot of you have already heard them, but they bear repetition, that the United States, the richest country in the world, has 5% of the world's population, has 25% of the world's prison population. 1 in 100 people in this country are behind bars. 60% of people in prison are of color. African Americans are incarcerated at 5.6 times the rate of whites, Latinos at twice that rate. And these criminal justice policies, largely fueled by what is now kind of widely accepted failed war on drugs, have really decimated communities of color in very, very profound ways. The election also has not changed the fact that we still don't have comprehensive immigration reform, and I recommend the New York Times editorial today, which kind of said it as much more eloquently than I ever could. But we're waiting, and it's taken too long. Our government for the last decade and a half, has been really over-relying on enforcement as kind of the answer. Our detention beds in this country have increased 6 to 7-fold. Immigration detention is the fastest growing form of incarceration in this country. Conditions in a lot of these facilities are absolutely deplorable. ICE has gone without enough accountability and oversight in running these facilities. There has been a moratorium, thankfully, on the raids. That is one thing that has immediately changed in the new administration. But there is a lot of work to be done. We simply cannot detain 12 million individuals, and that we need to figure out a path to legalize citizenship, or at least legalized residency in this country. And that is also at a real crisis point. And of course, when you listen to talk radio on immigration, there is a lot of preying on racial animus and fear about kind of who is the appropriate American citizen and who is the appropriate recipient of benefits in this country. And I think that immigration is very much a race issue that we now need to spend a lot of time working on. Education has largely been touched on, but I just want to say a couple of points. Again, the election doesn't change and hasn't changed yet the fact that there are a number of school districts, far too many, where less than 30%, 30 to 50% of Black and Latino students are even graduating from high school, feeding directly into the criminal justice system. We call that phenomenon now the school-to-prison pipeline that Sherilyn referred to. And racial isolation is really afflicting these schools in tremendous ways. It's having a real impact, since we now know and have known for decades that green follows white. And these are just kind of some of the examples where inequality remains very much a part of American society. And in fact, as Sherilyn also cited too, the economic recession has only made that worse. I think that people of color and communities of color have suffered very distinctly because of the recession, though that isn't necessarily part of the conversation, or enough a part of the conversation when we're talking about the economic recession, and things are likely to get worse before they get better. So I think it's really too soon to tell whether the 2008 election is going to make a real difference in terms of leveling off inequality and increasing opportunities for communities of color. There's a lot of proposals and plans right now. I will say that nonprofit organizations, advocacy groups have for the last 10 years spent too much time being on the defensive, trying to really curb government incursions on rights, trying to figure out what to do with Supreme Court precedents that has really limited the available remedies to address inequality. And now there's a different energy among the advocates, a real kind of hope that there will be progressive policies put into place to where we can actually affirmatively address inequality. I think the Department of Justice, we look at the executive branch, it's got a real opportunity to reestablish its credibility and its role in enforcing civil rights. Department of Justice, the Office of Civil Rights. But these positions are just, have just recently gotten filled or are getting filled. And I think it remains to be seen what's going to happen with that. With the economic stimulus package, I think actually really affords us an opportunity to do something about marginalized communities. The Office of Management and Budget had instituted or issued implementing guidelines back in April for the American Recovery and Reinvestment Act. that talked about non-discrimination and ways to actually make sure that communities of color or other marginalized communities are going to have access to those funds, and that the funds will be distributed in a fair and equitable manner. Again, it remains to be seen whether that will actually happen, and I think that the ability to make that happen rests both with the executive and with the communities in which the funds are going to be doled out. There's a lot of possibility in criminal justice. There's a tremendous movement to reform crack cocaine sentencing laws, to look for alternatives to incarceration, and I think largely not driven by necessarily the election, but actually, ironically, by the economic recession. It's simply become too expensive for states to continue to do what they have been doing, which is to outspend or spend far too much money on incarceration, even at the expense of education, and sometimes spending many times over in incarceration. I'm less optimistic about the Supreme Court. I think that there's obviously a possibility of and I hope for increased racial diversity, but the political makeup of the court, in my mind, is unlikely to change anytime soon. And it's hard to see whether increased diversity is necessarily, given the political makeup, going to translate into different outcomes. So do I have tremendous hope? Yes. Do I think that enough has changed yet? Of course not. It's been a very short amount of time. But I think, Barack Obama said it himself on election night. He said, this victory alone is not the change that we seek. It's only the chance for us to make that change. And I think we should have this panel really in 2 years or 4 years to do a true assessment of how the 2008 election may or may not have actually impacted policies that really are affecting communities at the ground. And so we'll have to see what we do with that chance.
Thank you. Thank you. Debo.
Thanks. I've enjoyed the remarks of my fellow panelists, and want to start with a couple of quotes that some people have shared on this question of whether or not we're in a post-racial society. Some of them may be known to you, and you can get a sense of where they're coming from. At the time of Obama's nomination to the Democratic Party, the top of the Democratic Party ticket, Abigail Thernstrom declared that the voting rights battle is over. Following the election, Ward Connerly shared the following explanation. The argument that American society is institutionally racist, that the good old boys are the only ones who can succeed, is decimated by the election of Senator Obama. So those are two expressions of this post-racial idea. Perhaps happily, their views are not the only voices on the question. The Washington Post, in a piece, framed it this way: now some people want to look to one solitary black man to just erase the so-called race problem. Call it the "I love Obama, thus racism no longer exists" phenomenon. Colin Powell put it this way: with each passing year, with each passing generation, with each passing figure, we move closer and closer to what America can be. But no matter what happens, in the case of Senator Obama, there are still a lot of black kids who don't see the dream there for them. And so obviously this is part of a larger conversation, as Sherilyn set out at the beginning. There are those who, as Vanita said, were both afraid of the election and then proclaimed it as a magic cure for all that has ailed us for 400 years. And I think that most of us probably don't buy into extreme views on this question. It's significant, as Vanita has suggested. I think we would do ourselves a tremendous disservice not to acknowledge the significance of the election, particularly in view of our history. We have done something. It is a statement about the possibilities of our Constitution. And I think that's what we have to keep in mind, the possibilities of our Constitution. The Constitution orients us in a direction toward equality, but we only move in that direction through sustained efforts. And it's with that lens that I want to turn back to the voting rights issues and share some of my perspective on those questions. I think that it's fair to say that the Voting Rights Act case now pending before the Supreme Court is a more significant constitutional moment than a particular judgment about a prosecution, about a particular alleged election infraction at a polling place in Philadelphia in the 2008 election. I know that's the position of the Department of Justice, and I want to talk a little bit about what's at stake in this Voting Rights Act case, and also what we can learn from the 2008 election itself. I mean, we draw from it outcomes, but I think fewer people have looked beneath the surface, and so we have to look beneath the surface before we even respond to the claim that the voting rights battle is over. In 2006, when Congress reauthorized the Voting Rights Act, whatever folks may think, they studied the problem of voting discrimination carefully. The record speaks to it. It was a detailed analysis of voting discrimination in many jurisdictions. Mr. Rossman has said that the percentage of Section 5 objections, that's the statute that's in play in the Mudd case, the federal preclearance provision that many of you are aware of, that the percentage of voting changes that are blocked is very small. That is true as far as it goes. It also is not the right focus. The percentage has always been small, as David Tatel, who will address this group on a different topic, observed during the oral argument in the lower court. At the time the Voting Rights Act was passed, the number of objections was very small. It was almost non-existent, and then in 1970, a pulse started to get into the Voting Rights Act, but it was never large. But voting discrimination is a way to affect the rules of our democracy. It is a way, by definition, to erode our fundamental promise of participation, to come as equals and to have a voice. And so when you're an elected official who can affect the rules of the game and manipulate the rules so as to carve out voices because of people's race, that is some of the most corrosive discrimination that our society has got to experience. So if it's a single voting change, but it has to do with the state of Texas, and it deprives minority voters the opportunity to elect candidates of their choice, then I guess somebody could say, well, that's just one change. But that one change may affect tens of thousands of people. It may put an incumbent in office who does not deserve to be there under a fair system. They may be there for a long time because they may come to have an incumbency advantage, and people will start to be disillusioned in the fact that their voices are not being counted. So I got that question from Justice Roberts at the oral argument about the number of objections that have occurred under Section 5, but any close reading of the impact of that transformative statute, that statute that perhaps speaks best to the extent to which our Constitution can mean something and can be a framework for which to improve equality, I think to focus on the number of objections contextually doesn't tell the whole story. Of course, there were hundreds and hundreds of these objections that were, and we call that small in number, but hundreds and hundreds multiplied by the number of people affected matters a great deal. And I want to move just quickly so we can get to the discussion to the election results themselves, the 2008 election results, because there was a brief filed, an amicus brief filed by a number of professors that studied the election returns. And as many people were celebrating the symbolic significance of the election of the first African American to the highest office in our land, some people were crunching numbers to see how he achieved that end. And it was interesting. I mean, he certainly did get a whole lot of white votes. He really did get a whole lot of white votes. But when you start to break that down and you start to see where he got votes, I think Sherilyn mentioned that the overall percentage was 43%. But when you look to the covered jurisdictions, I think his performance with white voters, when I say covered jurisdictions, I'm speaking of the jurisdictions covered under the Section 5 preclearance provision that the Supreme Court is now considering the constitutionality of. His white vote totals in those jurisdictions were 20 percentage points lower than the national average. Indeed, 3 states that have figured prominently in voting discrimination for a long time, Alabama, Mississippi, and Louisiana, the respective white vote totals for President Obama were 10, 11, and 14% of white voters. There are those that would like to suggest that that is just a reflection of partisan realities, that tells us nothing about race at all. And for those people, I would like them to go look at some of the election returns in the primaries, and also note that in some states where Obama performed better, some of the covered jurisdictions in which Obama performed better, he underperformed other Democratic candidates on the ballot. So I think if you take a close study of what happened in North Carolina in terms of white voter support for Obama, it was less than other major candidates on the ticket. And so what does this mean? Polarized voting, we're likely to hear and have heard that those are individual choices. That is just between people that go behind the curtain, or I guess now it's not a curtain. Sometimes you may push a button behind cardboard in the modern day and hope for the best. That's just private behavior. That's not something that the state or the Constitution should be concerned with. But it is the interaction of the polarized voting patterns with the setting of the rules of the game that can lead to exclusion of minority communities. Where you have at-large elections, or even where you have a districting system, and you know that you have racially polarized voting, you have a lot of information that you can use to make sure that certain voices don't get represented in legislatures. That will affect the nature of the discussion in those legislatures and ultimately sometimes substantive outcomes. So from my perspective, I think calling us a post-racial society is more a slogan than a reality. It's not really where we are. It is aspirational and perhaps something that we should be aspiring to, but it's not actual. And for all of us who believe in equality, we have more to do. The ruling of the Supreme Court in the Voting Rights Act case will likely answer how 5 justices view the constitutionality of a core provision of the Voting Rights Act, but it will not likely tell us about whether or not there's continuing discrimination in the country. Congress already made that careful study and answered that question, and it's incumbent upon all of us to see that we rise to the challenge regardless of what the Supreme Court has to say. Thanks.
Thank you very much. Lots of food for thought. Well, I've got a million questions. Let me direct the first one to Terrence and Vanita. I noted this year that Black History Month was a little light. By that I mean, so to speak. By that I mean that I had the sense that people thought we'd kind of been having a Black History Month for the prior 6 months, and therefore we kind of didn't really need to do what kind of normally happens in many major American cities during Black History Month. And it got me thinking about this question of whether or not just talking about race or framing some of the issues that both of you were raising in the racial context is kind of off the table now as a matter of even strategy. And I think, Representative Carroll, you were alluding to this earlier when you were saying, you got to frame things as about economics in part because people will experience an African American leader as having this kind of power, and will imagine that the racial bludgeon is going to be used. So I wonder to both you and to Vanita, and Vanita, you raised a number of issues, particularly as it relates to criminal justice. Do you think that in this moment, one of the things that's happened is that the framing of the issue has to, in order to be successful, not be in explicitly racial terms? One, do you buy that premise? Two, is there danger to that? What is the continuing value of pointing out, for example, in the economic crisis, where many people are hurting, across race, but in which there are particular consequences, disproportionate consequences happening in minority communities? What's the value of continuing to frame many of these issues in the context of race.
That's actually an issue I really do struggle with, because on one hand, as a political being, I have to look at how do I continue to run campaigns, and anybody here from Colorado, no, I'm not running for anything else next. But as a political being, and you look at how do you get people elected, how do you run a campaign, how do you run an election, especially when you have African Americans and other people of color who are increasingly running in areas that aren't predominantly black or predominantly Latino. You have to answer that question. Do you make explicitly racial appeals? Is your campaign predicated upon policies that on the surface appear to benefit one group over another? And you look at those folks who have been successful around the country and running in non-predominantly African American or Latino communities, people like Cory Booker up in Newark, New Jersey. Well, that is predominantly African American, but he hasn't run an explicitly racial campaign. But Deval Patrick in Massachusetts, or we look in other places around the country, and they've had to back away from very strident racial language. It gets you elected, but at the end of the day, I don't think it's necessarily a good thing for us not to have the discussion about race and about the explicit impact of certain public policy decisions on race. Because we've reached a point, I think, and it was raised earlier about this, some people want to rush to a post-racial society. And I think the reason they want to rush to a post-racial society is because we're still very uncomfortable in this country in terms of talking about race. It's not something we really want to do, because we want to feel like we're beyond what happened in the Civil Rights Movement. We want to feel like we're beyond Bull Connor. And the truth of the matter is, when you look at the number of African Americans and Latino students who don't graduate from high school within 4 years, and in some places it's upwards to 60%, you can't really say that we're beyond that, because students of color aren't inherently more stupid than any other group of students. So there's something systemic and structural in the system, and we have to address those things. How we address those and still elect people and still have public policy that we can get a large group of people behind, that's a good question. And I just want to briefly talk about criminal justice, because it was raised in terms of how we start to change that system. That's a classic example of you have two things going on at the same time. One, you have to frame the cost of the system in an economic sense. But at the same time, there still has to be this outside force that says, by the way, this system still incarcerates more people of color than not in this country. And we're moving towards not incarcerating as many people, but only because, not because anyone feels morally compelled because we're incarcerating more folks of color than anything else. It's because we can't afford to do it anymore. I look at my own state, and out of our $17 billion state budget, we spend nearly 10% of that on criminal justice. And we can't continue to do that. So we're closing prisons down, and we're looking at restructuring our criminal sentencing scheme. Not because there's a black man who's Speaker of the House. It's simply because we can't afford it anymore. And I've spent years yelling, hey, we got too many black folks and brown folks in jail, and we're not really criminals. But it finally got everyone's attention when they realized, oh, wow, the state's going broke. How do we fix this? Well, we have to restructure our sentencing scheme and start closing down prisons.
Well, thank you. Vanita?
As a litigator, I have multiple responses, but it's interesting. I'm a racial justice, civil rights litigator, but I would say that the number of cases that I've ever filed that have an explicit race claim are far and few between. And often I'm filing cases where my clients are of color. The issue is clearly one about race, but what I'm doing is talking about that kind of in the introduction, but not putting in an equal protection claim and framing it and trying to get at the problem through a whole host of other possible claims. And that's the reality that I work and live in, and I feel like I make that strategic decision, or the organization I work for makes a strategic decision on behalf of our clients, because we ultimately want to see relief for our clients. That's our duty, and we have to, if it means that courts are gonna close their eyes, close their ears, or else we're creating the risk of adding to the baddie of bad law. These are considerations that I have to take every time I'm evaluating how to build and litigate a case. But I think that there is a real risk in doing that, obviously. I don't actually, I kind of have accepted that I have to do that in litigation, at least for now. I hope that one day will change. But and I will still make equal protection claims where I just have to make them. But I think that in some ways there were, when you're talking about Katrina or the criminal justice system, it is impossible to talk about those, I'm just taking two examples, to talk about those two without talking about race, no matter how much you can code, and use socioeconomic status, or the courts are telling us that we can only use socioeconomic status. I think at a public policy level, sometimes, you have to talk about race because that is the thing that is front glaring, and there's simply no way to whitewash that, literally. And so, I do think, you go to, we have communications conversations about how do we frame criminal justice issues, and people talk about there's two ways to do it. You talk about public safety, you talk about expense, and those are the ways to advance campaigns. But there's, again, the statistics are what they are, and without an acknowledgement of race, there's simply not going to be a real reform. But I don't think that ultimately that's what is persuading policymakers to make the changes that those of us who care about racial justice want. And we have to be strategic and smart about how we frame things. And I think largely it depends on the context, it depends on the issue. But I think it would be a real detriment to think that socioeconomic status will ever fully explain the phenomena of race and racial injustice in this country. And so I think advocates, racial justice advocates have to, and people seeking change in certain areas of race, of policies that disproportionately affect certain groups, have to be very careful and about thinking about their context, their audience, their fora. And so I don't think there's a one bullet answer to that, but I think it's very context specific.
Great. Dave, you said you wanted to get in on this?
Yeah, I think it's an important question, and as I was listening to the other responses, I was reminded of a story that John Lewis tells in his autobiography or biography, where he tells the story of when Martin Luther King came back from having won the Nobel Prize. This is in 1965, I guess. And he takes a trip to the White House and meets with President Johnson. And the president is congratulating Dr. King. And as John Lewis tells the story, Martin Luther King was focused on demanding a federal voting measure to protect voters in the South because of what was going on. And President Johnson, a very talented politician, an experienced guy, told Dr. King that the country was tired of civil rights because the Civil Rights Act of '64 had just been passed. And so there was a need to press pause and wait until things could be lined up. And then, of course, came Selma and President Johnson's speech before the joint houses of Congress, one of the great civil rights speeches demanding a federal voting measure. And it was that led to the act that I defended a couple of weeks ago. So in thinking about that story, I found it fascinating as I was studying the Voting Rights Act to see that at the time that people were being murdered in the South, murdered to vote, and wholly disfranchised categorically, there was this sense that it was too much of a burden to talk about race in some way, that the country wasn't willing to indulge the conversation, or that we had exhausted a reservoir, that we needed to sort of push it to the side. And so those pressures will always be there, and it's our abiding hope at LDF that we won't need to be litigating race cases for the next 50 years. But history tells us something, and there is honesty on the side of still talking about race. It has that to recommend it. And so I tend to think that's important. I was struck in the parents involved case. There was a question, and I can't remember whether it was Justice Souter or Justice Ginsburg who asked, why should we pretend that it's not about race if what we're talking about is bringing students together? Why should we fashion a legal rule that causes us to ignore the problem that we're trying to address? How does that advance the law? This is not a quote, but this was the idea. You can go back and check the transcript. I'm sure they said it better than I did. And, they were urging this point. They didn't win the day with that argument, but it just seemed to me to make so much sense that there was a certain honesty to it. And so those of us in the advocacy community, we have our role, politicians have their role, and the media has theirs. We all have to keep doing what we do, but not shrink from the reality that we know to be true.
Speaking of media, one of the most refreshing moments that I saw during the campaign, this was, I think, around the time of the Democratic National Convention, was on Joe Scarborough's program on MSNBC in the morning. And one of those mornings, there'd been lots of, kind of up close and personal about Barack Obama and his story. And at one point, Joe Scarborough was there with two other white male commentators, and he started to say, that he actually thought there might be some resentment among some white men about Barack Obama, and that working class people might be looking at all of his accolades and his education and saying, kind of, how did this happen for him? And that there is this white working class ethic out there that is also struggling, and therefore kind of might have a backlash against Barack Obama. And this brings me to something that you said, Michael, that I thought was really interesting. You talked about kind of the sympathy for the plaintiff in the Ricci case, and we've seen a lot of discussion of this case in the media, and I would agree with you that a lot of the context has been around a kind of a sympathy for the plaintiff. I wonder if you think that that same kind of well of sympathy that we're seeing play out in the media is at all influenced by the election of Barack Obama. In other words, let's say John McCain was president. Would the conversation about Ricci be different, and if so, how, and does it matter?
Yeah, I really don't think so. I mean, I think individual factual situations like the New Haven case sort of speak for themselves, and that I like to think that it's not a consequence of Barack Obama having been elected president. It's obviously just a guess, since we're talking about a counterfactual that we can't go back and test, but that's my impression.
Okay. I wanted to ask you all to be a little bit more concrete now about some of these areas that we've talked about. Educational opportunity is one that Representative Carroll has mentioned several times. Obviously, we've talked about voting, and I think we may be even a little bit clearer there because we've got, a Supreme Court case. We've talked about criminal justice. I wondered if each of you would identify two things that you would hope could be implemented or could move to ameliorate whatever is your own sense of injustice, inequity in any of these areas. And here I'm particularly talking about educational opportunity because, Representative Carroll, you talked and have mentioned several times the very serious education disparities that exist in a number of jurisdictions in my own city of Baltimore, where anywhere between 60 and 70% of young black men do not graduate who enter high school. What are the two things that you think need to happen to address that? Vanita, you've talked about, over-incarceration and criminal justice, and so it would be helpful if you identified something from those areas. And I would leave it to Michael and Davo to choose any of the areas that you wish. But if you wanted to kind of make something happen that would be transformative in this moment, what would they be? One or two things, very quickly.
Sorry, you go first.
No,
Michael.
what order? I was just.
Michael, why don't you start then?
I would say that I think Vanita's comments about suggested that the war on drugs is a serious issue, and I have to say I'm not that familiar with the method in which public education is financed in this country, but what little I know about it is that a serious change in that way that's done would have some very important consequences.
Thank you.
Those are my two things.
Okay, Terrence?
Actually, Michael stole one of mine, which is in the school finance area, and briefly to explain how most public schools are financed, and it's mostly because of an equal protection issue. Most public schools are financed through the property tax, and each student throughout the country is, in each jurisdiction, is actually given a certain dollar amount that they're worth. For instance, in Colorado, every student's worth about $5,500 each, and that money follows the kid, kind of. The problem is that that system of funding schools, it turns out to be inadequate when it comes to our most at-risk students and our most struggling school districts. So we actually have to find a way to move beyond that mode of financing schools and back away from the property tax method. The problem with that is that most states are broke, and there's really no easy way to make that transformation. But if we are serious about school and education reform, the first thing we have to do is move away from the property tax basis for funding schools throughout the country, because it's actually failed. The second thing that we have to do, which is a little bit more unpopular, especially among the teachers union, is to have a long, hard look at the way that we educate our teachers. And I'll take a long, hard look at the folks who we bring into the teaching profession, and that directly addresses teacher quality. I'm not saying anything I haven't said publicly before on that one, but I do think that we have to aggressively move in that area in terms of teacher performance and teacher recruitment. And I think there's some studies that have shown, in fact, I know there's some studies that have shown that that can make a significant difference.
Thank you. Vanita.
On criminal justice, I think it's the main answer to me is kind of pretty basic. It's to increase the sentencing options that judges have right now, and to allow them to divert people into alternatives to incarceration. I mean, there's ending the crack cocaine differential, there's changing sentencing reform, but engaging in sentencing reform. But I really do think a lot of that boils down to the very limited options that judges have, and then also, I guess, as a follow-up, the limited investment in alternatives to incarceration. I do really think that we could vastly reduce our prison population, and I'm talking in the hundreds and hundreds of thousands on that level, if we were to engage in some really kind of groundbreaking, thoughtful reform around alternatives to incarceration. And then, because we had brought up some, immigration as well, I mean, I think that looking at paths to legal citizenship or status in this country, I think is really critical. It's not just affecting people who are referred to as undocumented, but also to U.S. citizens of Hispanic descent who are kind of also being victimized by the over-reliance on enforcement and the increased use of local ordinances to try to crack down on undocumented immigration. I think this is a really big problem as well.
Thank you. Davo, very quickly.
Very quickly, I join the views of others in the area of criminal justice. I think that we're at one of those de Tocqueville self-interest rightly understood moments where it is both the economic pressures and in the war on drugs, interestingly, the rise of methamphetamine sort of shifting some of the people who are going to jail behind drug convictions, that is sort of changing the demographic of populations, which is something that hasn't been looked at very carefully. But I think that there's an opportunity to reconsider the massive investment of state monies on housing in the form of incarceration to something that could be more community sustaining. And in that regard, I really think that what I would describe as the Katrina malaise, which is the response of the federal, state, and local governments to what happened in the Gulf, is something that needs to be freshly considered. It's astounding that we, as the society that we hold ourselves up to be, can allow that storm to so decimate a community, have such a disparate effect on vulnerable populations. And I think that if we focus on it more seriously and with all of the energy we need to make it change, it could be a gateway for some of the spending of all of these dollars to think more actively and affirmatively about vulnerable communities throughout the United States. And that's something that, again, self-interest rightly understood, that's not just black and brown communities. There are other communities that are vulnerable, to be sure. But as these massive infusions of cash go out there, there's no reason that some of it shouldn't be directed at people that are right there on the margin. They are Americans, and we have a duty to them.
I hope you all are preparing your questions. I'm going to ask one more question to give you time to assemble your thoughts. How are we going to do this? Are people writing them, or oh, you've got a mic? Okay. So let me just quickly ask this question. Hate crimes. Attorney General Eric Holder said that having effective hate crimes legislation is going to be a priority of this administration. I want to ask, do we need it? I periodically go on the Department of Justice FBI website to look at hate crime statistics. And I think we have a problem with what we currently have. I think we have a reporting problem. So, for example, it's fairly normal for the state of Alabama to report somewhere around less than 10 hate crimes a year. Very few jurisdictions report, if you actually look at where they're getting the reporting from. Mississippi reported 0 for 2007. As compared to Iowa, that reported about 55, Florida about 188, Maryland about 150. We have a serious reporting problem. I don't hear a whole lot about this. Where does this fall on the radar? Does it fall at all? Anybody can take this one. I guess it doesn't fall on the radar. And that's quite interesting.
I think it's, well, I'll start off by quoting Saturday Night Live. Really, Mississippi? Really?
Zero.
Yeah, really, Mississippi. I mean, we report more than that in Colorado.
Yes, you do.
I think effective hate crimes laws, are very important. We have some fairly significant ones. We've actually passed significant hate crimes laws in Colorado over the last 5 years, mostly because it sends a strong policy message that in your state, in your jurisdiction, that you take seriously the idea that certain groups of people, whether they're for their color or their sexual orientation or their religion, shouldn't be targeted for crimes, and it sends a message that you think that's wrong. There's an argument on the other side from folks who are, some civil libertarians and some civil rights activists who would say that, any act of violence against someone else is per se a hate crime, and they're right to a degree. But again, the purpose behind hate crimes laws is not necessarily for the aggravators. It's a message. It's a public policy message more than it is a strong criminal justice message.
Well, let me invite each of you to go back to your respective states and ask them to report hate crimes. All right, it looks like we've got questions, and the mic's coming.
The two senators that spoke to us spoke about how life experience matters in terms of the way we see the world. And I was thinking about that in terms of this nexus of do we concern ourselves or think in terms of race or economics. And I guess I always came down sort of on the race side because that's part of my life history. But I've begun to notice, and I'm a Washington, D.C. native, I've begun to notice more and more in the last 5 years that as we have a larger and larger African American middle and upper class, that when I sit on a grand jury, the break is by economics in the discussion in terms of what needs to be done. And the African Americans beyond a certain class tend to say it's not the schools, it's the kids. And so I'm hearing a type of racism that if I heard it from whites, I'd say that's racism. But when I hear it from African Americans, I can only say that's economicism. And so that becomes another part of this play that I think needs to be addressed, that it's no longer a coherent group that understands what it means to stand for race. I'd like you to comment on that.
I got stuff, but go ahead.
Okay. So I think that that certainly a generation or two ago, it was easier to have things be focused insofar as the vast majority of African Americans, particularly in certain parts of the country, didn't have tremendous access to capital and opportunity. And so it was easy to orient around the idea of Jim Crow and
No, I'm saying among the African Americans, they were all clear of what stood to be a non-racist society, what they wanted. And they spoke for all African Americans, and if you're doing that, they also spoke for the economic underclass, fine. But what I'm hearing is too often African Americans who no longer address the issues which they see are the fault of poor people, and that's what's the problem.
Can I take a
If that
shot?
same person made that statement,
Yeah.
it was white, it would be a
Yeah.
racist statement.
It's
Still is a racist statement, but I have no way, but that person happens to be black.
I think the only thing I would just caution you on is the underlying premise of the question, which is that there used to be this kind of unified vision, and now it's fractured. There has always been very dynamic and sometimes disparate views within the African American community about race, about racism, and about civil rights. Always. I was just doing a book review about a biography of Ida B. Wells, and just spending a lot of time in the writing of the period in which she was an activist, and seeing the kind of dynamic and contentious discussion that happened among black leaders. The difference, I think, is the feeling of being under siege when one feels one has to speak with a more unified voice in all instances. And I think what you're hearing and what you're beginning to see is the willingness of people to open up and to say things that we would only say behind closed doors, but to say it publicly, because there are so many more African Americans at all levels of society, relatively speaking to the past, and that means that you're going to hear much more of the multiplicity of views that exist within the African American community and that always have. The reality is that where we are in this moment now, I think people feel more freed up to be able to say things like what you're describing on a grand jury. But I also think that when you get down to certain core issues and certain core solutions, you still find a tremendous amount of uniformity. I don't find it problematic, what you're describing. I don't find it to actually be racist. I think it's perfectly fine for African Americans to have different views about what ails our communities and what the solutions to those are. I just think what is happening is that people are encountering in public spaces the articulation of those different views which they haven't in the past. So we had a question here and here. If we could get the mic on this side. Right in the front.
My name is Asa Gordon. I'm Executive Director of Douglas Institute of Government, and I'm chair of something called the D.C. State of Green Electoral College Task Force. I presently have a civil action that is pending before the U.S. Court of Appeals, and is it's called the Democratized Electoral College. Arkansas, Georgia, Louisiana, Tennessee, and Texas award their presidential electors on a winner-take-all basis. The problem is there is no winner-take-all state statute in those states. So the suit is simple. It says in those southern states that are subject to the 1965 Voting Rights Act, you must apportion your presidential electors predicated on the popular split. If you don't have a law that says winner take all, I invite amicus brief, all of you, to assist me in that. It's very simple.
What's the name of the case again?
The case is, well, it started off
What's
as
it now?
Gordon versus Cheney.
Okay.
And it was filed on the century and 2-score anniversary of the passage of the 14th Amendment. It is now Gordon versus Biden. It is now www.electors.us. I'm going to give each one of you a flyer that has the website. All of the pleadings are there in PDF format. And so it's very simple. Now, what it says is, and it's predicated, it's filed under Section 2 under Florida. Unfortunately, many of you attorneys are not familiar with Section 2 of the 14th Amendment. Section 2 actually penalizes states that abolitionists were serious by reducing their representation predicated on that disfranchised population. So I say in these states where you have no law, then you can only count on a winner-take-all basis. Then you can only count presidential elections in those states that's predicated on the strength of the white vote. And you cannot include those presidential electors predicated on the black vote, which you have not counted on the percentage of their participation in the vote. Very simple.
Thank you.
Now, that means...
Wait. Okay, do you come into a question, or we got to...
And now what that means is that this guarantees any Democratic Party from these states, of these 32 electors in the next election, regardless of how much they try to manipulate the election. Now,
okay, no. We have to stop now. You've given us the website, and we now it's 10 minutes to 1. Okay, sir, please. Sir, please. Can we get this on the website if we go on? If we go on www.electors.us?
It's very short. Please.
20 seconds.
All right, 20 seconds. Understand, Obama did not win the white vote. He won 41%. He's for 43% over 41% over Kerry. He increased, however, among African Americans from 88% to 95%. The black percentage of the total vote increased from 11% to 13%, while the white percentage of the total vote dropped from 77% to 74%. And so without the black vote, McCain would have won by 325 electoral votes if it was just whites voting. And if white males voted, it would have been 425. So let's just keep this in perspective.
Thank you, sir. Right behind, right there. Thank you, sir.
Thank you. I'm from out west. My name is Cheryl Harris. I teach at UCLA, and I have a question for Representative Carroll. Having lived with the racial effects of purportedly colorblind policy in the form of Proposition 209 in California for the last 10 years, I was very interested in the last 2008 election, the effort to sort of export our toxic waste to Colorado in the form of an anti-affirmative action initiative there was unsuccessful. Right. And I'd like to, there hasn't been much in the press that has talked about that, and I'd like to know what your thoughts are about why that initiative was defeated in Colorado. I know in California it was sold on many different lines, along the line principally around education, which is that eliminating affirmative action would actually allow the state to fix K-12 education. And as we sit here now, California is, I think, virtually tied for Mississippi in terms of funding and educational outcomes. But in any event, I'd be interested in your comment. Thank you.
In Colorado in the 2008 election cycle, we were forced to confront Ward Connerly in the guise of something called Amendment 46, which was the Colorado Civil Rights Initiative. I think it was kind of termed that way initially. In full disclosure, I was part of the initial litigation team that fought this and our what we call our title protest process, and it worked its way up to the Supreme Court, and we lost that fight because you lose most title challenges in the Colorado courts. They're just hard to win because of some legal principles that we have there. One of the reasons that I believe that we won at the end of the day, and trust me, we were all kind of shocked on the election night. We really were shocked. We worked our behinds off to kill the thing, but we were shocked on election night. And I think one of the reasons that we won is one that we got out early with a counter message in many of the communities of color and said, this is not about civil rights. This is about denying your kids access to college and about denying your kids access to a quality public education. And that was our immediate pushback to destroy the notion that this would expand civil rights. And then we built, led by the ACLU and some other groups, a fairly broad grassroots organization that just out-hustled and outworked on the ground Ward Connerly's organization, and I think they thought that their money would push this. But we actually had a much better grassroots organization that hit the ground and worked very hard on the ground. And then the other thing that I think worked in our behalf was the face of this, the public face of the pro-Amendment 46 crowd, just downright nasty folks. I mean, there's just no other way to put it. And the way they phrase their campaign a lot of times was, we have people of color who are getting things they shouldn't get, and that was so easy to push back, especially in a state like Colorado, where the truth of the matter is there's no affirmative action for all intents and purposes in Colorado because of the nature of our state law. And when you look at our higher ed system, we're at Grutter, way before there was Grutter, in terms of the matrix system, race being just one factor among many in terms of determining higher education admissions and things like that. And there's no affirmative action really in Colorado and public contracting. And so it seemed the Amendment 46 thing seemed overkill in our state for many people. And at the end of the day, we just were able to show that that we didn't want any more California imports. That was a message that was put out in the campaign. We've had enough from California, and they can keep whatever. I mean, there's actually a strong anti-California sentiment in Colorado.
These are the things you learn.
Because they pushed our housing prices up.
We'll take one more question.
I'm State Representative Fred Kessler from Wisconsin, and we're still in session, and Saturday night at 5:30 in the morning we passed through the Assembly our state budget, and I was involved in a battle in which I was successful in, for the first time, putting a cap on the voucher system. But what was very interesting in that is that my six colleagues who were African American were split just about down the middle on support and opposition to the voucher system. And in Wisconsin, that voucher system, as incorporated by virtue of our state Supreme Court, parochial schools, Lutheran and Catholic schools. I guess on one hand, I see the failing public school system, but at the same time, I really also understand that this is a movement to decimate the public school system. And I guess I'd like to hear the thoughts of the members of the panel of what direction should we be going with things like government-sponsored voucher systems that create alternatives to public education.
I'll start off by saying that I'm not surprised that your African-American colleagues were split on supporting vouchers. And the reason I'm not surprised is that there's a great deal of sentiment, I believe, in communities of color that education is the next big civil rights battle. And when you look at most of our public schools throughout this country, the number of students of color who aren't graduating within 4 years is absolutely abysmal. And so it's very hard for many African American and other legislators of color to continue to say that the current system, the way it's constructed, is the best system for students of color to be educated in. And the reason for that is that we've had the same system essentially in place for well over 100 years, which is an agrarian-based model. Kids go to school for 9 months, they take 3 months off to go work in the fields. We don't live in that type of society anymore. Secondly, the system's predicated upon this notion of a bell curve. So our most at-risk students get left out, and our most gifted and talented students get left out, and we educate toward the mediocre middle to a large degree. And so when you look at that confluence of issues, there's a great deal of pressure to try to find a way to reform the education system. And some people believe that a voucher system, which has its own issues in and of itself, and I don't support vouchers, in principle they're somewhat appealing in principle, but in practice they tend to lead to more segregation, and the schools that you really want your kids to go to don't accept vouchers most of the time. And so it just doesn't work as a system and practicality. But I'm not surprised by your colleagues who are African American, because there is a great deal of frustration with the way the current system is set up. And you can't say that it's all the students, when you can look across the country and you see that students of color just aren't graduating from high school. There has to be something more there than just simply the students are failing. And it's a structural issue. And one part of the structural issue, this is a direct racial component, and you look across our school districts, on average, more than 70% of our educators in our public schools are white, and they grew up in communities that are completely unlike the communities in which they're currently teaching, which creates a huge disconnect between the student and the educator. And that's why I talked about teacher training beforehand to create some sensitivity. So vouchers are one of those things where, within the Democratic Party in particular, it's becoming a dividing line between African Americans and Hispanics and the rest of the Democratic Party for the most part.
We're going to take one more comment on that question.
And I just want to add that I think that there is, when you're talking about education and fixes to education, to me there's a real danger of kind of relegating vouchers as kind of the answer or the silver bullet to what's going on in the system and the problems that we're seeing. And I do think that there's going to have to be a real look at housing and residential segregation and the role that plays in the disparities that we're seeing in education today. And that's a very, very difficult question to tackle for a whole host of reasons. But I think, if you're going to get at it at a structural level and kind of understanding that vouchers is just kind of almost a symptom of what's going on, then housing and residential segregation is a big piece of that puzzle.
We're going to have to leave it there so that we have some time for you all to network with us. Please join me in thanking our panelists.